Now we start the part 3. Please join me in welcoming the third panel. Ms. Miriam Rose Ivan L. Pereira, Counsel at Oebashi LPC and Partners Tokyo, will facilitate this panel. Please introduce members of your panel and start discussion.
Thank you. Good afternoon, everyone. It is an honor to be here with a very diverse group of ADR experts with both civil law and our common law backgrounds. So I will be moderating this session, and together, let's explore several expediting options to make arbitration proceedings more time and cost efficient for the benefit of the parties. So let me now briefly introduce our esteemed speakers. Let's start with Shinji Ogawa. He is an excellent arbitration and mediation case manager at the JCAA. Next, we have Julia Jion Yu, who is a partner of the International Arbitration Practice Group at Un & Bazul in Singapore and has represented clients across various industries in different jurisdictions. She also used to manage international arbitration cases as SIAC's counsel and head of the Northeast Asia desk. Next, to my left is Tony Andriotis. He's a partner at DLA Piper and leads their international arbitration team and has represented clients in both commercial and investment treaty arbitration. To his left is Yoshimi Ohara. She's a partner at Nagashima Ono and Tsunematsu and has served as counsel or as arbitrator in arbitration cases administered by various institutions, including the JCAA, ICSID, ICC, AAA, or ICDR, and SIAC. And last but not the least, we have our second Tony. Tony Diamond is a partner of Debevoise and Plimpton. He's a member of their International Dispute Resolution Group and co-chairs their Asian arbitration practice. Now, let me briefly describe today's panel. So expediting an arbitration proceeding calls for the close collaboration of all the stakeholders, including the tribunal, the parties and their counsel, and the institution administering the case. So each of them must be proactive. So for this session, we will talk about each of those stakeholders and see how they can contribute to speeding up the process. At the end, if we have time, we will take 1 or 2 questions from the audience here. So let's first look at the tribunal's leadership role in expediting and streamlining a proceeding. With this in mind, the JCAA has an innovative set of rules. Shinji, can you briefly share with us the interactive arbitration rules of the JCAA?
Thanks, Marlos. And before I get into the interactive rules, and I'd like to share with you this. In the last decades, there has been an ongoing debate about the role of the arbitrators. Should the arbitrators be simply receiving the file and also make a final decision as a kind of a passive arbitrators, or should the arbitrators take on a more proactive role by somewhat interacting with the parties, or even encouraging the settlement in the arbitration proceedings? And especially in this current uncertain and complex and changing world, proactive arbitrators could potentially assist the parties to reduce more time and costs, because conducting arbitration interactively with more assistance and guidance from the tribunal give the parties a chance to, number one, correct any misconception which the arbitrators may have, and also to focus their submission on the points that seems to be more relevant for the parties of the tribunal decision. And I have seen several international and proactive arbitrators in my experience, and let me share with you one example. And this tribunal was composing of the both common law and civil law oriented jurisdiction. And after the tribunal constituted, the tribunal proposed to the parties, one, shall we have a second case management conference or midstream conference? And also before the midstream conference, the tribunal shared the parties with the list of questions in the form of the parties' claims and defenses. And during midstream conference, the parties asked to respond to these list of questions and followed by Q&A session. And after this midstream conference, the tribunal revised the list, and the parties can use this as guidance, on which point the parties will focus on the subsequent proceedings. And finally, for the parties who seeks for more interactive or any proactive arbitrators, the JCAA's optional arbitration rules named the interactive arbitration rules might be an option. In these rules, the tribunal firstly will prepare the list of issues and prepare the summary of the parties' position for the parties' review. And also, more importantly, the tribunal will indicate its preliminary views with the parties at the agreed time of the proceedings and at the latest before the oral hearing. And finally, I'd like to mention briefly on the made-up proceedings. And I'd like to share with you one interesting international survey from the Mixed Mode Task Force is established by the College of Commercial Arbitrators, the International Mediation Institute, and also the Strauss Institute for the Dispute Resolution at the Pepperdine School of Law in the United States. And in response to the question, do you think an arbitrator has a role in fostering the settlement? And around 80% responded yes. So, and in fact, in the JCAA, some of the JCAA arbitration, the audio settlement was achieved with the help of the arbitrator acting as a mediator. That's my first comment. Thanks.
That's very interesting. So we'll talk a little bit about the role of the tribunal in sharing its preliminary views as well as facilitating settlement. But in the meantime, like the interactive rules, they seem to promote like more transparency and clarity for the parties. So for parties, what would they have to do, for example, to avail of these rules?
Yeah, and firstly, if the parties seek for the more proactive arbitrator at the outset, for example, contractual planning phase, it can include these rules in the contract. And for the first case under the interactive arbitration rules in the actual course, the parties opt in the interactive arbitration rules after dispute arise.
Can you share with us a little bit, like some details about that first interactive arbitration case?
So maybe the time is limited. And
just mention.
Yeah, the first case was successfully ended with the consent of the award, because after the tribunal indicated its preliminary view, the parties agreed to go to mediation and appoint the arbitrator as a mediator. And the party, with the help of this arbitrator turned mediator, the parties reached the agreement. They asked the tribunal to make a consent award based on the terms of the settlement. That's why.
Thank you. So now we'll talk about and hear from our other speakers what they have to say about the tribunal's role in sharing preliminary views or facilitating settlements based on their civil law and our common law backgrounds. Let's start with Yoshimi.
Thank you. Can you hear me? The mic is on. Okay. Well, first of all, thank you very much for having me at this wonderful event, and allow me to congratulate 70th anniversary of JCAA, and I wish best for the further growth of JCAA. So coming back to our esteemed moderators, question, I think in generally speaking, everyone would agree that parties wish to have proactive arbitrator. And Ogawa-san introduce a very successful proactive tribunal. But in reality, I think everyone would agree that we rarely observe this proactive arbitrator in the real world. Perhaps, arbitrators are too busy. Parties chose, so eminent arbitrator. They are too busy with so many cases. But in reality, I think there are two, issues that make arbitrator to act proactively, and I want to raise 2 points. So first, some, arbitrator, particularly those arbitrators from common law jurisdiction, they are very reluctant to share preliminary view at the early stage of the proceeding. That's not a part of their proceedings, in my understanding. Correct me if I'm wrong. They are always concerned about being perceived as prejudging or biased, and they're concerned about impartiality of arbitrator. So in the course of deliberation among the arbitrators for the purpose of preparing the proceedings, arbitrators from common law jurisdiction generally share reluctant view to even ask questions to the parties, because questions will reveal the impression of the tribunal members. But at the same time, being a party, participating in arbitration proceeding as a party or a counsel, you always want to hear or see where the tribunal is, what traveling tribunal, so that the parties and counsel can assist the tribunal and guide the tribunal to the conclusion in favorable to us. So the question is, how are we going to overcome this a sort of reluctance, particularly among the common law arbitrators from common law jurisdiction? I guess it might be, too challenging for those arbitrators to share preliminary view, particularly in writing, as suggested in the interactive arbitration rules. But perhaps so long as, tribunals can share questions or seek clarifications from the party, just like at the midstream, session, I think that immensely facilitate the arbitration proceedings because parties can see where the tribunal is and how they can focus your arguments in the rest of the proceedings. So rather than sharing the impression, but asking questions, I think, party would immensely appreciate that kind of, opportunity. Maybe JCAA can encourage more, even in the general commercial arbitration proceedings. The second point that makes difficult for arbitrator to become more proactive is once you share your impression, even if it is a preliminary impression, and making the reservation that, that initial impression can evolve subject to further submissions. It's not easy for, psychologically, it's not easy for arbitrator to change a position if you, clearly address their position, however it is preliminary. So again, sharing impression at the early stage may not be so easy to be done by many arbitrators, but asking questions could definitely, doable, even for common law lawyers from arbitrators from common law jurisdiction. The final point I want to say, again, about the proactive arbitrator, being an arbitrator, what is most challenging, what I found most challenging is whether the tribunal should raise an issue when parties haven't raised that issue. So, for example, there's a clear procedural error, but neither party brought up that issue to the tribunal. The tribunal members often discuss whether it's a role to bring up that matter when parties hasn't raised that issue. Would it be viewed as helping one party over the other? We're always concerned about the perceived impartiality. after having many, arbitration experience, my sense at this stage is that if it is not a substantive issue, and if it is a procedural issue that could affect the integrity of the arbitration proceeding, I think the tribunal should, raise that issue, even when neither party brings up that matter, because, if such procedure issues affects the integrity of arbitration award, then all the efforts and time and money that would be spent going forward would be wasted. So, so long as, the manner of sharing, a manner of proactive approach and the scope of proactive approach is properly structured, I think, the arbitrator from both common law jurisdiction, civil law jurisdiction can be proactive in the arbitration proceeding to facilitate the arbitration proceeding. And I think, JCAA, as an arbitration institution in the civil law jurisdiction, can even promote this, because this proactive arbitration is in a reflection of proactive judges in the court proceedings in many civil law jurisdictions. Thank you.
Thank you. So it sounds very challenging for the tribunal to be both proactive and not appear to be biased to the parties. Julia, what do you think?
So I would like to share my observation as a civil law lawyer educated in Korea, but working in Singapore in common law jurisdiction. My first observation from the common law jurisdiction, when we deal with arbitrators in common law base, it appears to me that they are very concerned about the enforceability. They are very concerned about the risk of any undermining the enforceability. They always put first the party autonomy, the parties' agreement, unless otherwise arbitration rules clearly stipulates the arbitrator's power to compel the parties to go into the negotiation or mediation. But the civil law jurisdiction arbitrators, my observation is that they are more like a guardian's role. Yeah. So they try to put forward the cases, if there is any possibility to settle between the parties, they always try to find the possibility. So that is my observation between the two different jurisdictions.
Thank you. So it sounds like the tribunal should strike a balance between party autonomy and its own discretion to manage the proceedings. Tony, our first Tony, what do you think?
I'm the first Tony.
Yes.
Okay, I just want to confirm that I am the first Tony. That is now on the record. Yeah. So first, I just want to say how delighted I am to be here, and particularly in this wonderful Mitsui club. And one of the biographical points I like to mention about myself, because I do like talking about myself, is that I was actually a salesman for Mitsui & Co.'s subsidiary in New York City. In my youth, I was selling industrial textiles for Mitsui. So I've never been invited to the Mitsui Club before. So I guess my hard work and efforts in New York were forgotten. It's good to be here, though. I also am delighted to see the efficiency of the JCAA in organizing the event, and in particular for bringing together so many diverse stakeholders. I'm hoping that this is a first step, and that in the future, we can look forward to a Tokyo Arbitration Week or a festival or event similar to what our neighbors in Korea do, where we will invite all the institutions, and embracing the point about the JCAA's original document from 70 years ago, in which international relations and showing of friendship is extended out and that we'll have CEC in the room, and we'll have ICC in the room, KCAB in the room, which is now, and I'm looking forward to that. Now to the question at hand. Thank you very much, Miriam. I think that party autonomy is paramount at all times. I think that a wise arbitrator will steer the discussions toward one in which the parties are the ones making the decision, but they are making a decision that is one in which may have been seeded in their minds by the arbitrators. I'd like to discuss one of the most simple, efficient issues, which sometimes is not about civil and common law differences, but it is definitely about cultural differences. And that is the issue of the almighty tree, paper. I know there are some of us who like A5 binders, these little tiny binders. I, as a practitioner and as an arbitrator, loathe them because I am old and I cannot see what's written on that paper. I also loathe them because they are heavy and they are hard to transport from place to place, and they kill trees. I think we should, as an arbitral tribunal, if we're looking for efficiency, should make it clear to the parties that electronic submissions are welcome, and we should have the parties themselves agree to electronic submissions and put that into the initial order, or if we're dealing with a terms of reference where the parties themselves agreed to it, put that right in the front, make things easier. Along the same lines, I would call for some kind of communication protocol. Remember, we are dealing with international arbitration. We are dealing with many, many different types of parties and many different types of counsel. We should make sure they understand that ex parte communications with the arbitrators is not acceptable behavior. We should have to lay out, because sometimes parties may feel that their party appointed arbitrator is still working for them because their bread is being buttered because they were chosen. I would say, however, that that type of thinking needs to be changed right in the beginning at the initial meeting, and a communication protocol should be set up. If there is a procedural question should either be asked directly to the Secretariat or should be asked to the arbitrators, and the other party should be copied in on that. Another issue that comes up that is very clear in common law and civil law is that of evidence. We're going to be covering that later. But as a general rule, the discussion of what can be exchanged as evidence should be put on the table very, very quickly. As an American lawyer, we do love our discovery. We like to exchange documents in a very transparent way. We like to see everything the other side has. That being said, most American lawyers who are in international arbitration do not embrace that. But we need to understand that these are things that need to be discussed on the onset, in the very beginning, because they will help move things along quickly and efficiently. As to communication protocols and document exchanges, thought should be made as to whether or not emails off of your own servers would work just fine, and whether or not an FTP site, a file transfer protocol site, should be set up that is in a neutral third company, for example, or whether it can belong to the chamber or the law firm of the presiding arbitrators. These are all questions that should be dealt with very early on in order to help move the arbitration forward quickly and efficiently. Another thing is, we talk about the discussions of the interactive rules. I just want to say how much of a huge success it is that there has already been one case using the interactive rules. And I say this, it might sound like I'm being sarcastic. I am not. I say this because the Singaporean government, for example, is spending millions and millions of dollars talking to us about the Singapore Convention. There have been 0 cases of enforcement under the Singapore Convention as of yet. There has been 1 case of the interactive rules being used. This is a very good thing. Now, as far as my views as to whether or not an arbitrator should be taking that kind of mediating role, it depends on the parties, to be clear. and on the rules that are being used. I would take pains to push forth the mediation aspect, but I would let it be known to the parties that mediation is always an option. Put it out there right in the beginning to frame the proceedings moving forward. I've spoken too much about how beautiful this Mitsui Club is, so I yield my time.
Thank you, Tony. Now let's listen to the second Tony, and it doesn't mean anything.
Second Tony.
Thank you, Miriam. Thank you. I'd like to echo the other panelists in saying what an honor it is to be at this event, and what a absolutely fantastic venue. So we've already heard a little bit about the differences between the common law and civil law approaches, and I mean, in a way, it's a shame that we're still actually talking about those, because when an international tribunal is sitting in an international arbitration, they should have forgotten the tradition from which they have from which they're drawn. They should be able to synthesize the best of both worlds. And the best tribunals do exactly that, but sadly not everybody does. We've heard that the common law common lawyers typically don't like the idea of tribunals sharing preliminary views, and I think that's right. And I think amongst most common lawyers, med-arb, where the arbitrators become mediators, is pretty actively discouraged. As a common lawyer, I would say to my clients, actually, it can undermine both processes. If you're an arbitrator acting as a mediator, are the parties really going to trust you with information that they're not prepared to provide to the other party in a way that you need to be able to do to make a mediation work? And it can also frustrate the arbitration if the arbitrator acting as mediator hears things from one party that are not passed on to the other party. So I think there are some real reasons to be a little bit concerned about med-arb. Other forms, such as the form that has been proposed by SIAC, I think probably work pretty well. So ARB, med-arb, where it's actually sent off to another body for the mediation, and you have that separation. As far as providing preliminary views are concerned, I'm a big fan of that, but I think it needs to be done by consent. And I think consent is needed to avoid charges that the tribunal has prejudged the case and to give rise to due process concerns. But I think even where there isn't consent and tribunals are not volunteering their views expressly, they will find some way of communicating their concerns about a party's case. And it might be through the way they ask questions. It might be through simply being asked to be addressed on particular points. And a good tribunal will be able to indicate where it feels that parties need to focus their firepower. But in order to be able to help settlement or express a view, and even to fulfill their central purpose of running the arbitration efficiently, the tribunal's got to understand the case. And too often, tribunals don't understand the case until very late in the day. And that's not their fault. Often they haven't been taught the case by the parties. I think that it is very useful for parties to be able to educate the tribunal at an early stage of proceedings. I like the idea of doing that as early as possible in the proceedings, to have some kind of a soft opening. Can even be done at the very first CMC. And lots of tribunals I know do encourage that, but actually parties are their own worst enemy. We often blame tribunals for not being on top of the case, but actually we don't educate the tribunals about the case. And in part, we do that deliberately. We're often reluctant to disclose our cases until very late in the day because we want to maintain maximum flexibility. And then we turn around and blame the tribunal for not understanding what the case is about, which is, in my view, completely unfair. So if it can't be done right at the beginning of the case, it should be done as soon as possible. And one of the things that we've learned from COVID is that remote procedural hearings work extremely well. The days of jumping on planes, traveling halfway around the world for procedural hearings are, I think, behind us. We no longer have to have only one procedural hearing at the start of an arbitration and possibly a pretrial review before we get into the main evidential hearing. Tribunals can, and I think in many cases they should, check in with parties regularly, ensure that timetables are on track, experts are squarely addressing issues, and check in to see whether tribunal intervention of any kind is required. At the same time, they will be developing their understanding of the substantive issues in the case. And I think using remote hearings in this way really opens up the dynamism, the flexibility of international arbitration, and allows tribunals to intervene in a way to shape the procedure for arbitration so that they are as efficient as possible.
Thank you so much, Tony. So there are many ways and tips that we have heard for the tribunal to be proactive. And it really points to also the parties and their counsel helping out. So we will now talk about some of the options that proactive parties and their counsel can consider to streamline their proceedings without sacrificing fairness. So Shinji, you were instrumental in revising the JCAA's rules in 2021 to expand the application of expedited procedures. Can you briefly describe them?
Yes, thanks. And the first read, that if the parties want to speed up the procedure, and the simplest way is to agree on the time limit for the award in the contract. And actually, I saw recently cases where the parties agreed to set a timeline for the award in the contract. And after dispute arise, the dispute amount was significant, but still, as agreed by the party in the contract, that the tribunal shall issue the final award within 90 days. Finally, the sole arbitrator appointed by JCAA issued award mostly on time with a short time 1 month extension. And also, to make the process faster, we need to consider the option for streamlining the procedure. And the expedited procedure has those two components, deciding on the award issue and also to simplify the procedure. And the JCAA introduced this expedited procedure in 1997. It's almost over 25 years ago. And in 2021, we revised the arbitration rules and to expand the scope of the expedited procedure. For example, we increased the threshold amount where the expedited arbitration apply. And also we set a strict time for the issuing the final award, depending on the case, within 6 months or 3 months. And interestingly, I'd like to share with you, I saw the one case is where the parties agreed to use the expedited procedure after the dispute arose, even though the amount of disputes was way over this threshold amount. But still, the arbitrator appointed by JCAA conducted the 2 online case management conference and followed by a Q&A session, and also conducted 1 short hearing online. And successfully, the arbitrator issued the final award within almost on time, and 1 or 3 weeks extension. And yeah, that's kind of my explanation about the expedited procedure and also how to expedite the procedure in my actual case.
Thank you. So now let's turn to Julia. Can you share with us an enforcement issue that involves the proper construction of the tribunal in the context of an expedited proceeding?
I just learned from Ogawa-san. Actually, I didn't know that the JCAA introduced expedite procedure almost 20 years ago. Wow. I thought that the SIC was one of the arbitral institution, quite early introduction of the expedited procedure. But Yeah.
That's
it
high
was a
praise
good-
from you.
Yeah. So what I want to address here is about, so when you expedite your arbitration proceeding, you always need to weigh between efficiency and the parties' agreement or parties agreement. And for example, in your contract, of course, before the dispute arose, in your contract, let's say you draft arbitration clause with 3-member tribunal. But after disputes arose and you realize that you have to expedite your proceeding, so you under the contract arbitration clause, the SIC arbitration rule, and you make the application for expedited procedure. And then under the SIC rule, if your application will be accepted, instead of 3-member tribunal stipulated in your contract, the sole arbitrator will conduct the expedite procedure. So this enforcement case actually happened in the Chinese court. That happened in the arbitration cases against the Chinese party. And the Chinese party actually, during the arbitration proceeding, they keep objecting about the SIC's appointment of sole arbitrator, saying that actually in their contract, they already chose a 3-member tribunal. But under the SIC expedited procedure, the sole arbitrator was appointed and the SIC award was rendered against the Chinese company. Of course, the winning party went to the Shanghai court to enforce that SIC award. But what happened in the Shanghai court was that Shanghai court refused to enforce the SIC award, saying that SIAC's appointment of sole arbitrator actually is contrary to the parties' agreement in their contract. And that was affirmed by the Supreme Court in China. So that was like a quite big issue and debate within the arbitration community. And
So Julia,
yes,
so what do you think the party should have done in that case?
Okay.
Like how could they have avoided that?
So that's why SIC, after this enforcement issue in Chinese court, SIC actually amended arbitration rule. So let me read it just for other institutions, the information. So in 2016, SIC has amended its rule saying that by agreeing to arbitration under these rules, where arbitral proceedings are conducted in accordance with expedited procedure, the parties agreed that the rules and procedures set forth in Rule 5.2 shall apply even in cases where the arbitration agreement contains contrary terms. Yeah. So I know the Miriam's question, what if the parties choose SIC clause with a 3-member tribunal, but when they want to go to the expedited proceeding, to reduce any risk of enforceability, SIC actually amended after this case.
Okay, great. Thank you so much. Let's talk a little bit about the feature of one of the key features of expedited proceedings is a document-only proceedings. And I know that Yoshimi has very, very strong views about this. So let's hear her views.
Thank you very much. I'm mindful of time. It's only 10 minutes left, and we should demonstrate our efficiency. So just quickly, one, of course, pros, the benefit of document only, it saves time and cost. I just want to highlight one, potential pitfall with respect to document only proceedings. Tribunals do not necessarily follow your oral, the written advocacy, the documents. Definitely, you should have an opportunity to check the tribunal as to whether tribunal truly follows your points. So even if, you know, document only proceeding, I suggest parties would agree to have one short hearing to make sure that to check the tribunal's understanding and to make sure that tribunal fully appreciate your written submissions. Thank you.
Thank you. And Tony?
So I'm going to be very boring. I agree with everything that's just been said. I mean, the caricature of the common lawyer is that we're completely focused on oral advocacy. We love witness hearings and we love extensive cross-examination. But, you know, the truth is a lot more nuanced than that. Lots of matters in courts are disposed of without oral witnesses, oral witness evidence. We do strikeouts, we do summary judgments, we have other procedures. It's true, most applications are oral, but some are on paper. Leave applications are often paper only. Appellate advocacy is principally on paper. You know, strike the right balance. What's most useful for the tribunal? What's fair to the parties? Much can be done on paper. You know, in the UK, we introduced adjudication for construction disputes many years ago. Most of those are done entirely on paper. But I do agree that, you know, if you've got a really complicated matter, it's very useful just to have a short hearing. You get in front of the tribunal, address them on the points that are still troubling them, make sure that they followed your written argument. So there you are. I've already spent too much time repeating what's gone before me. So there it is.
Great tips. Thank you. And now let's hear from Tony. Tony, let's continue with you. Based on your experience as counsel and arbitrator, how should parties and their counsel approach witnesses?
Approach what? I'm sorry.
Witnesses.
I think that this is part of goes back to the common civil law divide that's part of this main discussion right now. And I think that as an arbitrator, you need to be aware of both traditions so that sometimes you may not catch when there's an issue arising due to a cultural or traditional difference. So in many civil law jurisdictions, witnesses are just as much about the direct as about the cross, and that they expect to have a long time to put their case forward in the direct. They're not familiar with the witness statement covering that aspect of the case. And they may thus also try to bring up multiple witnesses that have basically the same information to present to the tribunal. I think as an arbitrator, you should be aware of the different cultures that are permeating in that tribunal, and you should see if one party from a civil law tradition, for example, puts forward 35 witnesses and the other party puts down 2, you may want to just kind of sit down and say, okay, what is your view of what the purpose of witness testimony is? What are you trying to get across? And to convey that it's not about that direct, it's about the cross. And the cross is when you make yourself weakened, where you open yourself up to attack. It's not right for you to tell one party you are making a mistake. But if you kind of take a step back, look at both sides and say, okay, I think we have an issue here, misunderstanding of what the role of a witness is, and say that we are going to be moving forward on an approach in which the direct will be minimized or eliminated, and it's all going to be about the cross. Do we agree to that? And if both parties agree to that, then you write it down that the parties agreed to it, to keep a record, and then you move forward in that way. So my approach to witnesses is to be aware that sometimes the parties may have different traditions, and then also be aware that sometimes the parties and the counsel for the parties have different levels of experience. And it's very important for the tribunal to catch that and try to make it so that that difference in experience does not lead to a situation that could raise matter dealing with due process later that could invalidate the award, or that can lead to a matter that will greatly complicate the situation and slow things down.
Thank you very much. So now that we have 5 minutes left, we will fast forward to the final question. So we will look at arbitral institutions like the JCAA and how they can be proactive. So I would like to ask each of our guest speakers what they think institutions can do to secure faster, efficient, and economical arbitration proceedings. So let's start with Julia.
So I will give very brief my suggestion to the arbitral institution. So for efficiency, effective arbitration proceeding, I think the secretariat's role would be quite important because in SIC, there is a kind of internal assessment on the arbitrators' conduct in arbitration proceeding, because the case counsels can closely observe how these arbitrators proceed and conduct arbitration cases. So based on the Secretariat's assessment, that arbitrator would be recommended or appointed once again, or no more opportunity. Yeah, so that is what arbitral institution can do. And I think less of extension of time. So there are always like a time limit to give like a partial award or the expedited award, something like that. Then there is very vague reasons on when the arbitral institution can confer the extension of time.
That's right.
Yeah, so I think the less of extension.
More feedback and time management. Let's hear from Tony, the second Tony.
So earlier today, Takashima-san touched on users' concerns about time and cost, and they're very real concerns, and they have been for as long as I've been involved in arbitration. Summary proceedings are a really important tool for addressing some of those concerns. And a number of our Asian institutions have got rules that address summary proceedings. So, for example, SIAC has Rule 29, which deals with early dismissals of claims and defenses, and HKIC rules. Article 43 deals with early determination. Now, the important thing is that tribunals have always had these powers, secret. And for example, the ICC rules don't directly address summary dismissal or early determinations, but I've made summary judgment applications in ICC arbitrations. Including these powers reassures tribunals and enforcing courts that tribunals have those powers, and it discourages challenges. So I think that's a good thing. On balance, I think it's a good thing because they're important procedural devices and they are currently massively underused. The only downside is that the rules get longer and longer. You know, when I started in practice, the ICC rules were, you know, like that. They're now getting longer and longer. And, you know, a whole point of arbitration is to get away from these procedural rules of hundreds of pages that you know, typify domestic court proceedings. So there's a sort of aesthetic challenge, if you like, but I welcome these rules.
Thank you. So procedural clarity. So we have 2 more minutes. Let's hear from Yoshimi and then Tony and then Shinji.
Thank you. Thank you. So what does the arbitration institution, what do? They, you know, introduce rules, they administer case. So for rules, they can introduce, you know, expedited procedure, time limits, or penalize arbitrator who is not efficient and diligent. But at the same time, as a parties, we do not want to be imposed on a new rule. So sometimes, you know, arbitration institution change the rule and automatically apply the latest rule, even when the parties enter into chose that institutional rules well before such amendment was introduced. So tribunal, the institution should be mindful of the impact of the rule change as well. Second, administration. Sometimes I see parties, counsel, or arbitrator, tribunal members who are not really sophisticated. I would like to see more institution assist tribunal member or counsel who are not necessarily sophisticated to help them, you know, help them run the proceedings or help them, you know, make submissions most efficiently.
So we need more stability and guidance. Tony?
I like the way that Julia put it in terms of we're being judged by the institution as arbitrators, because sometimes you meet arbitrators who think that they've been anointed by the Lord himself to serve as a tribunal master. And we are not judges appointed by a sovereign or by a religion or by anything. We are people, and we are normal, and we try to become experts in the field. I like the idea of the institutions putting rules upon us. And one of the rules that the ICC has, for example, is that they will penalize you financially. If you're late on an award, they will deduct a portion of the fees you're supposed to get as an arbitrator. Okay, thanks.
Thank you. And our final word from Shinji.
Yeah, and thank you for having an opportunity to speak last and to make a last comment. And thank you for all the panelists giving me and also the JCAA to consider how the proactively as an institution to promote a more cost and time controlled procedure. And especially I love the idea of the assessment of the members, the conduct, because especially for the information to the parties, and but also if the JCAA appoint arbitrators, the parties would like to know which kind of experience or the background or the expertise these potential candidates are. So one of the most information the party look for is how these arbitrary candidates would proceed the proceeding efficiently, or even more these candidates will be more proactively conducting the arbitral procedure. So these kind of ideas are loved, and I and JCAA will need to consider these good example and good ideas into to improve my services or our services, JCAA services for the future.
Thank you. So we look forward to the JCAA improving its services for everyone. And thank you again for joining us. Let's give our speakers a big round of applause.